you're looking at the other end here of the screen, that's Alan Haley. He doesn't have his cape on right now,
No.
but he's a superhero attorney, and we just had a big win in the Diocese of Quincy. And to give a little background here, many years ago, the Diocese of Quincy voted to leave the Episcopal Church by changing their bylaws and canons and all that's needed to do and require. They did it correctly. They did it to the laws of the state of Illinois. They were sued, of course, by the Episcopal Church. They end up in court. Today, they had their day in court. What did the judge say?
Okay, the judge essentially held for the Diocese of Quincy on the grounds of neutral principles of law, which more and more courts are signing on to, as we saw in Texas just a week or so ago. And under the neutral principles of law, the court does not get involved in church arguments over structure, doctrine, and polity. It looks simply at the documents. And here was at issue in this case was a bank account. It's somewhat accurate to say that ICUSA sued the diocese, but what happened was that ICUSA first of all sent off a letter to the bank in Peoria and had it freeze the funds of the diocese without any court proceeding or action whatsoever. So the diocese was forced to start the suit in order to try to unfreeze the funds. This decision now unfreezes those funds and says there was no canon or provision in the Constitution of ECUSA which provided for the church to come in and take over the bank account of the diocese just because the diocese chose to withdraw from the association, which is ECUSA. So that is what is going on here, and why it is such a signal victory, because as I think maybe we discussed on another occasion, when the trial in Quincy took place this last April and May, it stretched over about 3 weeks. Thousands and thousands of attorney hours had gone into preparing this case, assembling the documents for this judge, and those hours were largely unpaid and submitted.
Yeah, that's an important part. Obviously, there's many people that worked here. Yourself, a couple other attorneys.
We had Alan Runyon from South Carolina come in and help with the trial, and of course we had the two local attorneys who've been soldiering on this case now for more than 5 years, and that's Tad Brenner and Kent Schnack of Quincy, and so they are the real heroes in this. But everyone put in long hours, is my point, and we submitted for the court, and the Episcopal Church submitted for the court a stack of documents, each of us about this high, so double that, and that's what the court ended up having to go through and wade its way through. And this judge, Thomas Ortball, is the soul of patience. He has the perfect judicial temperament. He never gets upset or flustered. He allows both sides full time to present all their arguments, all their best evidence. He makes his rulings as required on admitting evidence, but he's generally allowed both sides full rein to put on whatever kind of case they wanted. And ICUSA called only two witnesses, Dr. Bruce Mullen and Bishop Buchanan. And the Diocese of Quincy put on, of course, a number of other witnesses, including Ephraim Radner.
Well, yeah, that's an interesting point, because the people they put on were threatened.
Yes, for testifying.
That was something that was unique about this case, that we haven't seen that used, well, at least publicly,
right,
by the Episcopal Church before. Up to 7 or 10 or 9 people, bishops, were written up and threatened with Title IV stuff going on.
Correct. Father Radner and Bishop Beckwith, retired Bishop Beckwith, were two of the Diocese of Quincy witnesses who were specifically threatened with some sort of retaliatory action. And I'm sure the court did not appreciate it. It doesn't mention that in its opinion, but that had to be a factor behind the scenes in the account, because anyone who tries to intimidate the other side's witnesses into not testifying obviously has some weaknesses in their case that they would rather not have come out in court. And so this judge, as I say, did an extremely thorough job and patient job. He had the case under submission since May, and it's now almost October's, or beginning of September, and we have his it's a 20-page decision and order, making detailed findings, and the sum total of which, as I say, is that there's no rule in the Episcopal Church that prevents a diocese from leaving. And even if there were such a rule, if for example, now General Convention in in reaction to these decisions, tried to pass a provision in the Constitution that said no diocese can leave without the permission of General Convention. That rule itself would arguably violate the First Amendment's freedom of association. All of the dioceses in the Episcopal Church came together originally, the founding members, in 1789, including the Diocese of South Carolina, and formed the unincorporated association. It's never been incorporated, and it's never been organized under the laws of any one state, which we call the Episcopal Church today. Mm-hmm. And that's a free association of dioceses, member dioceses. They are the ones who are the real members of the Episcopal Church, not the individual parishioners. And so those member dioceses coming together in an association have a First Amendment right now to associate as they please, and that means the freedom to associate is the freedom to dissociate, to withdraw. And so, again, the judge's decision didn't have to go there because he found that there was just no rule of ecclesia that tried to prohibit it.
Now, before we go any further,
yeah,
there's two things I want to talk about. Can the Diocese of Quincy go for damages?
Well, it will get money detention damages, in other words, interest on the sums that will have been detained, and that will depend on the legal rate of interest in Illinois, I'm not sure, versus what interest that was earned while the money was held in the brokerage account. So definitely they can get some sort of compensation, yes, for the withholding of money like that.
Second question. An answer to court, good or bad, can always be appealed up at appellate court, different chains. There's no end game until finally the Supreme Court of the U.S. decides to take your case or not take your case.
Right.
What do you think is the progress? Is this done now, or are they going to go and appeal it?
Yeah, what will happen now is after a judgment is entered, then they'll have a certain amount of time. The rump diocese. Well, actually, the rump diocese is no longer around.
That's gone.
They have to prove that the Diocese of Illinois is now the legal successor to that diocese. That'll be fun. Yeah. And then Episcopal Church itself can file a notice of appeal up to the Fourth Circuit Court Appellate District, in Illinois. It covers Adams County, and that appellate court will render in due course, probably 2 years from now, its own decision. But given the thorough job done by Judge Ortball, I can't see them wanting to improve on it much or come out in a different fashion. But who knows? And then once they decide, then there's a further possibility of appeal up to the Illinois Supreme Court, and from the Illinois Supreme Court to the U.S. Supreme Court. Both of those latter two steps are discretionary, and you're not given a right of appeal. The court decides if it wants to take the appeal based on the subject matter of the case.
Today, as of probably 10 a.m. Central, the Episcopal Diocese of Fort Worth can now write checks.
Yes. You said the Episcopal Diocese of Fort Worth. You mean
Quincy. There's so many dioceses out there.
Right, the Anglican Diocese of Quincy.
Can now write checks.
Well, it's going to take a while. There will have to be a judgment entered first, and that be given to the bank, and then that will free up the funds.
All right, well, that's great. Alan, I want to thank you for the report. Now, we'll obviously be following this. I expect an appeal. I expect the whole rigmarole from Tech, because this isn't a little loss.
Right.
Neutral principles is a huge loss. You cannot have judges ruling on neutral principles if you're fighting for property you don't own.
And this decision, I think, provides a clear guideway for all future judges to approach these issues. That's why it's so crucial. He did it right, he followed the law, and he applied it carefully, very carefully, to all the facts. And I can't see any other judge finding any kind of fault or error in this. They will want to follow the same analysis. That's why it's so important. Okay.
All right, that's you. Get back to work.
Okay.
God bless.